and welcome to today's monthly meeting. My name is Ashley Burkett and I'm the chair of Northern Ireland Safety Group. First of all, I will extend a very warm welcome to our speaker, Barrister Ronan Daly, who's going to talk to us today, and then we'll have a Q&A afterwards. Ronan, if it's okay, if you want to unmute and pop your camera on, and we'll just make sure, that you can share your presentation okay, and then what I'll do is I'll turn my camera and mic off, jump back on at the end to do the Q&A.
Ashley, can I check that you can see that okay?
Yes, I can see that.
That's us.
Okay, thanks very much, Ernie, and thank you, Ashley. Hopefully the sound is okay at my end. So the first slide that we have is entitled Here Comes the Judge, and then Ronan Daly, barrister, who is me, and today's date. And really this slide is just to give everybody a flavour for what we will be covering this afternoon in this presentation. The concept really is that we want to look at what happens when court proceedings start, if you are unfortunate enough to be involved in them as a defendant, as a company, or as an individual, and what the processes may be and what the outcomes may be. I'm a barrister. I've been working in this area and other areas for over 20 years. Your first port of call, if you are in the unfortunate position of having to engage in processes like this, will be with a solicitor. And the solicitor will, or firm of solicitors will deal with all of the initial exchanges that you have with the health and safety executive or the prosecuting authorities. At some point, it is most likely that your solicitor or firm of solicitors will bring in a barrister, someone like me, on the defense side, to help you to deal with the proceedings that have landed on your desk. The prosecution, which is the other side, there's always a prosecution and a defense. The prosecution will, for their part, have solicitors also, and in most events will also engage a barrister as well. Some cases are considered to be so serious that a Queen's Counsel or a senior barrister will also be engaged in that case. So we'll be touching upon some of those issues as we go through, and that's really just to give you a flavour of what's coming. So if we go to the next slide, please, Ernie. This slide again is an overview of what we're going to be touching upon, the prosecution process. So really what we're looking at is a situation where a decision has been made to prosecute you or your company for what are alleged breaches initially, and that decision, whether or not to prosecute you, comes at the end of quite a long investigative process. So you may have an incident at the workplace, and the health and safety executive may become involved and start their investigations. But it could take up to 2 years, maybe longer, for the decision to be made that you are going to be prosecuted or your organization is going to be prosecuted because the matter passes what is called the prosecutorial test, which is assessed by the Public Prosecution Service, and it is deemed appropriate to deal with the matter through the court process. We will also have a little look at how a verdict is decided upon if you do face the prosecution process, and the role of a judge in coming to the conclusion of that process, and what the judge can or cannot determine in relation to the process. So if we go to the next slide, please, Ernie. So this is a slide that we have put together to outline in broad terms the prosecution process. And the first box at the top indicates to you that when you have an incident or a serious incident in the workplace, that the HSE, NI, and or the Police Service of Northern Ireland will conduct an investigation. And as I've said, that can take a number of years. In some cases, at the moment, because of COVID and the impact that has had on the justice system, I am seeing investigations taking longer than that, which of course can leave everybody involved in a state of some uncertainty about what exactly is going to happen, and that can cause upset and worry and anxiety. But things have certainly slowed down across the board, unfortunately, as a consequence of COVID. So the diamond below that box refers to the fact that when the HSE/NI and or the police conclude their inquiries and investigations, that a file is sent to the DPP, and that essentially is the Public Prosecution Service, which is a separate service of solicitors and investigators and clerks, which determines whether it is appropriate or not to proceed with a court prosecution. Essentially, what those lawyers within the DPP will look at is whether there is sufficient evidence to potentially make out one or several breaches, criminal charges, or whether there isn't, and also whether it is in the public interest to proceed with a court prosecution. So those are called the evidential test on the one hand and the public interest test on the other. And the case should pass both of those tests to reach the point of being taken to court. On some occasions, the Public Prosecution Service will decide that there should be no prosecution, and that's good news for you as a company, an organization, or an individual. And on other occasions, they will decide that there must be a prosecution process, and that is initiated by way of a document that is called a court summons, which will arrive on the desk of you or your organization, and that really is the start of a lengthy process for you, and lengthy engagement with the court system and with lawyers in terms of how you're going to deal with that summons and how you're going to address the issues that arise within it. So if we could have the next slide, please, Ernie. Thank you. So going back to, this slide goes back to the summons arriving essentially on your desk, and what happens next within the court process. There are probably going to be one or two reviews of your case in court. All cases start off essentially in what is called the magistrate's court or the district judge's court, and those courts are dotted around Northern Ireland, and they can be very busy courts. We now have a degree of hybrid working with remote court appearance by lawyers, and also attendance in person. The official guidance from the Northern Ireland courts and tribunal services and the Northern Ireland judiciary remains that attendance should not be in court unless specifically requested by the judge or by the court. So remote access is commonplace by a system called SiteLink, which the court service uses. So you will then have an assessment when your case reaches the magistrate's court. You will have a feeling for whether it is going to be dealt with in the magistrate's court, or whether the proposal is to take it to the Crown Court. And the Crown Court deals with more serious cases in general terms, and it also has a wider sentencing jurisdiction. So if you're taken to the Crown Court, which is court with judge and jury, you face potentially more significant outcome than in the magistrate's court. There's a process, you will see the diamond in the middle, called a preliminary inquiry, and that is a process that is still in use in Northern Ireland. It has been phased out in other jurisdictions, and there is a proposal to do away with it also in Northern Ireland, but it remains in place. If it is proposed that your case is to be taken to the Crown Court, you have the option in the magistrate's court of a preliminary inquiry, which essentially involves the calling of the witnesses that the prosecution intends to rely on at a hearing, at a special hearing in the magistrate's court, where the strengths and weaknesses of that prosecution evidence can be tested, and a decision is made by the magistrate or district judge whether there is a sufficient amount of evidence to take the case further, to allow the case to proceed to the Crown Court or not. It is a very low bar at this stage. The test is reasonably easily satisfied by the prosecution, but nonetheless, it is sometimes considered to be a useful mechanism by defence lawyers to test the sufficiency of the evidence, or indeed, if you feel as a defence lawyer that there simply is some essential part of the prosecution case which is missing, and if an essential part is missing, the case should be stopped and not allowed to go any further. So the green box to the right, it says no case to answer. So the judge can make a determination at that stage that the case should go no further. Or the arrow down from preliminary inquiry is to committal, which is simply a reference to the fact that if your case, it has been planned to take it to the Crown Court and there is a sufficient amount of evidence at the preliminary inquiry, you can be committed forward for hearing, trial, or otherwise at the Crown Court. So in Northern Ireland, it's important that at each of these stages that there is a senior representative of your organisation present during the proceedings. As I say, ordinarily that is in court, but during COVID times, that can be remote, and probably should be in your solicitor's office. That would be someone as senior as a managing director, or someone certainly with a senior level of knowledge, and a senior position within the organization. That person essentially is nominated to represent the organization going forward, and the expectation is that that person will stick with the process to a conclusion. So Ernie, if you wouldn't mind just the next slide, please. This slide covers some of the options that you will be given when you are first in court, and you will see at the top a reference to the phrase arraignment. If your case is being kept within the district judge or the magistrate's court, you will simply be asked, how do you plead to each of the charges, guilty or not guilty? And if you're in the Crown Court, if your case is taken to the Crown Court, you will have your first formal hearing will be your arraignment in front of the Crown Court judge alone. And again, you will be asked, do you plead guilty or not guilty to the various charges. In ways, arraignment is a straightforward, or should be a straightforward, court appearance, but it is nonetheless an important one, because arraignment really is your first opportunity as a defendant to indicate whether you are pursuing a guilty or not guilty approach to the case, but also if you are going to be sentenced in the case at some point in time, the judge will look at when you indicated that you accepted responsibility in relation to the offence or offences, and arraignment is technically the first available opportunity for you to do that, and that will affect what's called credit. You are always given credit in court for an early acceptance of responsibility, and a discount in relation to any sentence. That's not to say that you should feel pressurized to enter a guilty plea if you retain the possibility and the anticipation that you want to contest some or all of the charges. And I think that's also important. You must weigh up the prospect of discount with the real prospect of contesting your case. So we see on the left-hand side the screen, summary trial or jury trial. Summary trial is a reference to in the magistrate's court the fact that the district judge on her own or his own will be listening to the evidence at trial and deciding on guilt or innocence, whereas in the Crown Court it will be a jury who will consider guilt or innocence at the end of the trial and at the end of the presentation of the evidence. If it's a not guilty verdict, then that's no conviction, and you go home in the same position as you had been that morning. If it's a guilty decision by either the judge sitting alone in the magistrate's court or the jury in the Crown Court, then the matter will be put back for what's called a sentence hearing. Thanks. Ernie, if we could take the next slide. Thank you. The verdict that the court will reach in relation to the charges that you face. As I've said, in the magistrate's court, that's the judge sitting on her or his own, listening to the presentation of the evidence by both the prosecution and the defense. Most cases, I have to say, that fall into any sort of more serious bracket are going to the Crown Court, or routinely go to the Crown Court, so you have judge and jury. Some, I suppose, of the less serious matters, generally speaking, do still go through the magistrate's court. Although my own involvement has much more been in the Crown Court domain. Looking at the bullet points, the underneath Crown Court, as we see, it's a jury who will determine on the evidence that's presented whether you're guilty or not guilty on one or more of the charges. The jury is of 12 people, the women and men on the street. Essentially, they are called for jury service, and the jury now, the numbering is basically computer generated. You have very few opportunities as a lawyer to object to someone being on your jury, so it really is potluck who ends up on your jury. The judge's role is to deal with the law and sentencing, if any, and the jury must always accept the judge's direction on both of those matters. The jury listens to the evidence as presented by both sides and makes findings on the facts, and those are the jury's decisions, and the jury will reach, or hopefully will reach, a verdict. The last bullet point refers to majority and unanimous verdicts. If everyone's agreed on the jury, that's 12 of them, well then that's a unanimous verdict, one way or the other, guilty or not guilty. A majority verdict can also be accepted after a certain period of time of deliberation, normally in the region of 3 to 4 hours. It's not fixed, but the judge will make a feel for this depending on the length of the case and the issues in play. So if 10 of the jury can be in agreement, well then that verdict of those 10, after that period of time has elapsed, can be accepted by the court. If the jury is divided or can't reach 10, then it is something called a hung jury. So that could be 6 and 6 or 8 and 4, etc. And a hung jury is not a verdict. So the prosecution essentially has to make a decision after a hung jury whether to bring a fresh prosecution again on the same facts, and whether to go through with the process again. So that can happen 2 or 3 times in an attempt to reach a verdict before a judge might say, I'm not allowing this to happen again. So jury deliberations are obviously always in private. You've no idea what has persuaded or not persuaded a jury. All you get is the outcome, if any, of the deliberations. So thank you, Ernie. Reaching a verdict on your case is the title of the next slide. The burden and standard of proof are important concepts in court, very important. So the burden of proving a case will always rest on the prosecution, and the prosecution legal team must call the correct evidence and do that in a structured way to persuade the jury of their case. The general rule, although it's not an absolute rule, but the general rule is that the defendant must prove nothing. And the standard that the prosecution must prove their case to is, in a criminal case like this one, is beyond a reasonable doubt. Again, that isn't defined. Beyond a reasonable doubt is not defined anywhere. It's not written down anywhere, but judges of all sorts of phrases and words that they use to assist juries in determining what is beyond a reasonable doubt. And one phrase that is sometimes used is, if you have to reach a very important decision in your life about something, be that personal or financial or something of that nature, are you persuaded about that decision, or do you have a doubt that is significant enough to make you pause and step back from the decision? And if you have a doubt of that degree, then you should not find that the case is proven beyond a reasonable doubt. That standard of beyond a reasonable doubt can be compared with the standard in other types of cases. For example, a civil case where, for example, about money or damages, or two cars crash into each other, or you're taking a case against your employer for some injury to your finger or something of that nature at work. Civil litigation goes on day in, daily across our courts in Northern Ireland, but the standard there is on the balance of probabilities. So it's really which version of the evidence the judge prefers. Whereas in these cases, health and safety breaches, which are criminal cases, the case must be proven beyond a reasonable doubt because they are regarded as more serious cases. There's one exception that we have on the slide, which operates in this field that we're dealing with, and that is where the burden of proof is reversed, and it's very important in these cases of health and safety breaches, and it comes under Article 37 of the Northern Ireland Order, the Health and Safety at Work Northern Ireland Order, and essentially it reads that in any proceedings for an offence consisting of a failure to comply with a duty to do something so far as is practicable or reasonably practicable, it should be for the accused to prove that it was not practicable or reasonably practicable to do more than was in fact done. So the employer has to prove that it is done enough, and that is quite wordy, but it's an important category, an important article for lawyers, because essentially many of these offences under the Health and Safety at Work order are grounded upon whether you as an organisation or a company has fulfilled your duty to do as much as is reasonably practicable. And that's a phrase which has caused all sorts of issues. But you can't just say, well, it's up to the prosecution to show that we haven't met that, we haven't done what is reasonably practicable. What the law says is that it's for you, the organisation, to prove. It's up to you to prove that it was not practicable or reasonably practicable to do more than was in fact done. So it's a significant shift in the burden of proof in criminal proceedings. It does occur from time to time in different fields within the criminal law, but it does put an organisation, a defendant, a company or individual on a bit of a back foot when it comes to that article. The next blurb relates to witnesses and evidence. As I've indicated, evidence will be called by the prosecution in an attempt to prove their case at hearing. Examination in chief is when the prosecution adduce the evidence that they want to from that witness, and cross-examination is when the defense gets its go to test essentially the prosecution witnesses. There are some other bullet points there. We have the bad character, which is a newish addition to the criminal law field, and it essentially says that if you have a criminal record of this nature, if you've had breaches in the past, have been dealt with in court in the past in relation to any broadly similar matter, that can be introduced to the court in relation to the case that you're dealing with at this time, and that includes in front of a jury. So it's an important matter if a jury is trying to determine whether you're guilty or not guilty of charges, and the jury hears that in fact you have convictions or something of that nature, sometimes not quite conviction even, but you've been dealt with in court, and the jury hears that that has happened before, then that can really sway a jury. It's a very significant piece of law. There are two other bullet points: hearsay and special measures. Hearsay in this context is often used to basically introduce documentary evidence, large swathes of documents in court in a case like this, without having to call the person that produced or was the author of those documents. And special measures is something like video links to help vulnerable witnesses, or sometimes it can be what's called a registered intermediary. It's various court systems that can be put in place to assist you in giving evidence or attending court where you have some vulnerability, or you may be in fear, or you may be anxious or frightened, perhaps of giving evidence against your employer, for example. And if you can satisfy the court that these special measures are required in your case, well, then the court can implement those. Next one, please, Ernie. The next slide takes us through to sentencing. So you will reach sentencing if you have pleaded guilty and accepted your responsibility for an offence, or if the jury has reached a verdict that you are guilty. So we see on this slide that in England and Wales, that as of the 1st of February 2016, very definitive guidelines in relation to sentencing have come into play. They haven't in Northern Ireland, and we will consider that before the end, but they are sometimes referred to by the courts in Northern Ireland in reaching a sentence, but it is not the same structured fixed approach that the judges use in England and Wales. There's no particular reason for the divergence between those two jurisdictions, but it's just the way things are at the moment. I'm not sure that there's any immediate plan to change the Northern Ireland situation, but you'll see the guidelines provide tariff-based starting points and category ranges for fines with a step-by-step approach for sentencing. So it really is very much a table format, and the judge in England or Wales will follow this tabular format in reaching a determination on fine. Some matters that are looked at are the degree of culpability, how responsible your organization is deemed to be, the risk of harm. So making an assessment of what the degree of risk was within the organization, how foreseeable that risk was, and how extensive the harm may turn out to be, size of the company, and various aggravating and mitigating factors. So a judge will take all of those into consideration. Next slide, please, Ernie. So these are the England and Wales guidelines, and it's a direct lift from those for you to see. Culpability will be very high where there's a deliberate breach or a flagrant disregard for the law, and that's reasonably obvious, I'm sure. It will be high where your organization fell far short of the appropriate standard. For example, failing to put in place measures that are recognized standards, ignoring concerns raised by an employee or others, failing to make appropriate changes following prior incidents, exposing risks to health and safety, allowing breaches to subsist over a long period of time, serious and/or systemic failure within the organization to address risk to health and safety. It will be medium where you fell short of the appropriate standard in a manner that falls between the high and low. So, for example, systems were in place but not sufficiently adhered to or implemented. And it will be low where you did not fall far short of the appropriate standard, for example, because significant efforts were made to address the risk, although they were inadequate in this occasion, or there was no warning or circumstances indicating a risk. So you can see the factors at play there between very high, medium, and low culpability. Next slide, please, Ernie. Looking then at the harm, and you will get a flavour for the way in which the court will categorise the seriousness of the harm. Level A, where there's a death, physical or mental impairment resulting in lifelong dependency and significantly reduced life expectancy. Where that meets a high likelihood of harm, which we've just looked at, you're into category 1, medium likelihood of harm, category 2, and a low likelihood, category 3. Level B, seriousness of harm, physical or mental impairment, not within level A, but still substantial and long-term effect on day-to-day activities, a progressive, permanent, or irreversible condition. And again, you will see where that meets a high likelihood of harm, it goes into category 2, a medium likelihood, category 3, and a low likelihood, category 4. Level C are all other cases not fitting in within level A and B. And you will see again where they meet the harm categories, they fall within 3 or 4. Next slide, please, Ernie. So in England, again, sentencing guidelines, the organisation size taken from turnover, annual turnover, is a very significant factor. And the court will scrutinise accounts in detail from probably three most recent years. And it in England, again, it categorizes organizations as a micro organization, so a turnover of less than 2 million, small 2 to 10 million, medium 10 to 50, large over 50, and very large, large up to 50, over 50, very large, considerably in excess of 50. Next slide, please, Ernie. And here you'll see some figures, really putting some numbers in all of this. So we start with the large 50 million and over turnover, and you will see there, well, the first example is where it's very high culpability and it falls within category 1. starting point is a fine of £4 million, and then a range of 2.6 to 10 million pounds, and obviously that's the most serious type of outcome. And then you go right to the bottom of that slide, and you'll see at the other end of the range, where harm category is 4, within low culpability, you have a £10,000 starting point and a range of £3 to £60,000. Again, I would stress that these are figures that we are seeing in England and Wales, but we're not yet seeing in Northern Ireland. Next slide, please, Ernie. Factors that aggravate or mitigate the outcome, the sentence. And on the left-hand side, you will see factors increasing seriousness, statutory aggravating factor, previous convictions, having regard to A, nature of the offence to which the conviction relates and its relevance to this offence, and B, the time that has elapsed since the other conviction. That's by statute an aggravating factor. And then other aggravating factors will include things like cost cutting at the expense of safety, deliberate concealment of the illegal nature of activity, breach of any court order, obstruction of justice, a bad health and safety record, falsifying documents, deliberate failure to obtain or comply with licenses, to avoid scrutiny by the authorities, and targeting the vulnerable. Factors on the other end of the scale then that reduce seriousness or mitigate, you'll see no previous convictions or relevant or recent convictions, evidence of steps voluntarily taken to remedy the problem, high level of cooperation with the investigation, good health and safety record, effective health and safety procedures in place, and self-reporting cooperation and acceptance of responsibility. Next slide, please, Ernie. These 2016 guidelines, then we're looking at the impact that those have had in England and Wales. And we now regularly see fines to organisations over and above £1 million. And the Merlin fine is referenced at £5 million. That was in September 2016. That's when the Alton Towers had their very serious incident when on the roller coaster, when one of the carriages carrying customers collided with an empty carriage and was stuck on the roller coaster at something like 45 degrees. The individuals inside were stuck at something like 45 degrees for several hours before they were released. And the people at the front, the customers at the front, had the most serious injuries, including amputations in some cases, and then a number as you move through the carriage, the injuries were less severe, but a very serious and a very unfortunate incident. It was Merlin's second significant incident in 2012. They had a death in Warwick, I think it was. And that would also, we see that there under previous health and safety conviction. So it was a very large organisation. The judge referred to that turnover in excess of 367 million. It was a high culpability. Harm category was 1. Previous conviction, exceptional level of cooperation with the investigation, and a 1/3 reduction for an early guilty plea. They really accepted responsibility at quite an early stage. Initially, they tried to blame some of human error and tried to blame some of the employees, but ultimately moved forward to accepting that it was a systems failure on their part. They essentially didn't have the right systems in place to deal with an issue which had arisen, and also to aggravate matters, they didn't have a proper system in place to release the customers who were stuck. And the fact that it took several hours for that to happen was seen by the judge as a significant aggravating feature. The 1/3 reduction for an early guilty plea, that it's not really fixed. Certainly in Northern Ireland, it's not fixed. We see anywhere between 25% reduction and maybe 1/3 at the other end of the scale. If you, as I mentioned earlier, at arraignment or at an early stage accept your responsibility, you will be entitled to remission of your fine. And in a case like this, the judge started off at £7.5 million and then discounted that to £5 million because of the early guilty plea. So you can see the effect in that case, a saving essentially of £2.5 million to Merlin for an early acceptance. But again, I would stress that, particularly in Northern Ireland, my own view is that you shouldn't let that become all consuming, and there is a long road between receiving your summons and getting a verdict in a case, and there are many twists and turns and avenues to be explored, letters to be written, and exchanges with the prosecuting authorities. The most serious type of case, of course, we have is a corporate manslaughter, and I've had 2 of those in recent years, and there were extensive exchanges on the basis of the evidence between the defence legal team and the prosecution legal team, and ultimately on the basis of those exchanges, the prosecution accepted that the charges of corporate manslaughter should not be proceeded with, and guilty pleas were entered in relation to some of the lesser charges. So that will give you a flavour of the work that can go on between barristers and between the prosecution and the defence, and behind the scenes, essentially, not always seen, and very often will involve detailed expert evidence, engineering evidence, consulting, forensic engineering evidence, extensive amounts of work that can be done to prove your defense or to persuade the prosecution that they should not proceed in relation to certain charges. And it's an entirely legitimate and accepted and ultimately a fair procedure, that if evidence changes or if the prosecution is presented with fresh evidence, they can change their mind on the basis of that evidence, and that's quite proper. Next slide, please, Ernie. We see here some of the impact that the sentencing guidelines have had, and pre-guidelines with the lighter shade and post-guidelines, the darker shade. As expected with large and very large organizations, there has been a very significant increase in fine levels, and perhaps less expected has been the increase in the other organizations. You'll see the medium and the micro or small. So the sentencing guidelines in England and Wales have led to much higher fines across the board. Next slide, please, Ernie. As I've indicated, they don't expressly apply in Northern Ireland, and whilst our courts have referred to the guidance, including the steps taken to determine culpability, level of harm, etc., when considering sentence. So our courts do quite openly at times refer to them, but do not expressly apply those guidelines yet. And then the next slide, please, Arnie. Case law, there is a body of previous decisions in any area of law that will be available to the prosecution and the defense, and ultimately to the judge, and those will be used fairly and properly by the lawyers presenting their case to the judge, and by the judge in reaching her or his decision. Judges can sometimes feel constricted by what has been decided in the previous case, and on other occasions will determine that the case before before her or him is on its own facts and has to be decided in its own way. We have court decisions. You will see their hierarchy of courts really in reverse order from the Supreme Court down. But really with that like any system, we have a hierarchy, and you have the right of appeal. If the verdict or if a decision doesn't go the way you want it to go as a defendant, in the Crown Court, you can appeal if a judge has got a point of law wrong and has directed the jury wrongly in some way. You can go to the Court of Appeal. From the Magistrates Court, you have an automatic right of appeal to the County Court, and there is a system there of checks and balances. So if something goes wrong, you often have the opportunity to have another bite at the cherry, and that's really what that slide is effectively for. And then the next slide, please, Ernie. Corporate manslaughter. We touched upon that earlier. I mentioned a couple of cases that I've been involved in, and it's a very specific, a very unique, and obviously a very serious charge. I think it is fair to say that it is being brought more often now in recent years in Northern Ireland than it had been prior to that. There were a number of years where it didn't really appear on our radar, but it is increasingly in play, and as I say, can lead to a significant accumulation of material and evidence by defendants to try and deal with it. But we've underlined here some of the key elements of the charge. So it relates to an organisation, the way in which the activities have been managed or organised, and obviously that must cause a death, and B, it must amount to a gross breach of a relevant duty of care. An organisation is guilty of an offence only if the way in which the activities are managed or organised by its senior management is a substantial element in the breach. And an organisation that is guilty of corporate manslaughter or homicide is liable on conviction or indictment to a fine. So that's where the bigger numbers, the bigger fines come into play that we were looking at earlier. But it is a very specific, it's a very specific statute, it's a very specific charge, and those elements have been underlined. All have to be established by the prosecution, and there are all sorts of legal and technical issues around all of those elements to the charge. And then the next one, please, Ernie. Oh, questions. So that brings us to the end of the presentation. Hopefully that has given everyone a little bit of food for thought. There are other things that come up from time to time. One that actually comes to mind was a prosecution of an individual, Mr. H, and he was a representative actually of a large organization, but it was an unincorporated partnership, and a prosecution or conviction for him was going to have very serious repercussions for his business and the way he did business and travel and all sorts of things. And he was quite aggrieved that if he had been a company, in all likelihood, the company would have been prosecuted, but because he was an unincorporated partnership, he was being prosecuted in person. And we ended up having a very lengthy written exchanges with the Public Prosecution Service, who eventually decided that they would accept that they could prosecute the unincorporated partnership, and rather than this gentleman in his own right, and that was a significant relief to him. And it's food for thought, I suppose, for businesses, how they structure themselves, how they want to organize themselves, what sort of entity they want to work within, and whether they want that corporate veil and the protection of the corporate veil in relation to offences like this one. It's one factor among various factors, but it does come into play in this field also. Okay, Ashley, I think we're at maybe at questions.
Ronan, thank you so much. I jumped on too early there, keen to start the questions as they've been coming in as you've been talking. Firstly, thank you so much for your time and for going through that this afternoon. I think it's fair to say that no one ever expects to be in a process like that, but I think it always helps to understand the procedures and the processes, because I think that can help if you know a little bit about that. I'll jump in now to some of the questions, and we can see what we can get through. The first one here is, I'm often asked about an employee signing a waiver, accepting responsibility for certain actions. I understand that companies have a duty of care to employees and responsibilities under the Health and Safety at Work Act or Order. Is there any value in doing this if it was to come to a civil claim?
It's a difficult one. I think in a civil claim, it would be one piece of the jigsaw, but I think it would be very hard to say that an organization has delegated its responsibility, and it would remain arguably vicariously liable for the acts of employees. So I don't know how ultimately a judge would, how persuasive that would be to a judge.
Okay. The next question then is, who decides when Article 37 is used?
It's a very as we've covered, a very broad and influential transfer of the burden, and it appears under the 1978 order. So any of the offences under the 1978 order which refer to the practical or reasonably practicable steps, if you look at those, you will find that transfer of the burden to the employer. And just to give you a flavour for it, Article 4 of the 19th and Article 5 are the two main ones under the 1978 order. And Article 4 talks about the duty of the employer so far as reasonably practicable to ensure health, safety and welfare of employees, and matters that duty extends to include, in particular, provision and maintenance of plant and systems of work, arrangements for ensuring safety and absence of risk in health in relation to use, handling, storage, transport of articles and substances, provision of such information, instruction, training and supervision as is necessary to ensure, so far again as reasonably practicable, health and safety, and maintenance of means of access and egress, and provision of a working environment so far as is reasonably, as regards facilities and arrangements. So that Article 4 is the employees, and Article 5 is non-employees, but people who are injured or hurt at work. It covers such a vast array.
It does.
Of offences, and then of course we often see in a summons or an indictment breaches of the various regulations which slot into Article 4 and 5. So really, in relation to any of those, the burden, where the word reasonably practicable is in play, the burden passes.
Yeah, I'm going to jump over a couple of questions because there's another one that sort of is on this topic, and it may be one that you would need to check, but Article 37 and the reverse burden of proof answered my question on so far as is reasonably practicable. Does this also refer to, sorry, each time I move that, it cuts off part of the question. Oh, there we go. Does this also refer to section 4.8 on the employee to take reasonable care for the health and safety of himself and other persons who may be affected by his acts or omissions? I think that might be a reference to Article 8 and the duties on responsibilities, which talk about reasonable care rather than the concept of something being practicable or reasonably practicable. So I suppose the question is, does Article 37 kick in for Article 8? But it may be one where you need to track it through the legislation just to see.
Yeah, my first feeling is that it's really about what is reasonably practicable for the employer to do. And I know we're focusing a little bit on Article 37, but the whole concept of reasonably practicable has caused the courts, endless problems over the years. And they say very contrasting things. They say things like, we don't expect a forensically perfect workplace, and you're not meant to reach superhuman standards. But then they go and find that where they go and find against employers, essentially, where an accident has happened. They often say the mere fact that the accident has happened very much displays that you haven't done what was reasonably practicable. So there's a real tension there in the case law.
Yeah, no, absolutely. The next question is, what if an employer states it is too costly to put health and safety measures in place?
Well, my general reaction to that is that won't play. A cost. It's not right to say that a cost is not a factor, but it's generally not a good one to rely on. I think something would have to be a phenomenally expensive, but if anything, especially when you look at the figures, the profit, the turnover, and so on, standards are high.
Yeah, absolutely. The next question then is it a misconception that the courts in Northern Ireland will tend to favour the plaintiff?
I think it is. I don't think you can say that. Every court, every judge, well, the plaintiff, of course, is a civil law concept. So
yes.
it's where you're taking a claim for something, or moving it. It's not a criminal concept, which is prosecution and defense. But you can't really say that. But different courts, different judges, different personalities. It's just life. It's just life.
Okay. The next question is, where do fines monies go? So if a company has to pay a fine, where does that go to?
My understanding that fines just go into a court fines unit, and then I think they make their way into the machinery of court processes somewhere along the line. There's no, I don't think it goes into the judge's pocket or anything like that. It certainly doesn't go into the barrister's pocket. But yeah.
Okay. The next question is about the sentencing guidelines. Just a query as to whether or not sentencing guidelines in England and Wales impact the levels of fines in Northern Ireland on an upward trend, and also if turnover for fines is determined by the corporate entity alone or by the wider group in terms of turnover.
Yeah, it's a good question. I think fines are on the up. I think I was looking at the various fines. The health and safety executive obviously have the outcomes on their website. And I suppose the thing to remember is that in Northern Ireland, generally speaking, we have smaller businesses. We have more sort of one-man, two-man operations.
Yeah.
We're SMEs. We're a country of small and medium-sized enterprises. So that's maybe why the judges have generally been a bit more gentle with sentencing, and you'll see that in some of the fines are gentle. But there's certainly where they get an opportunity for a big organization by Northern Ireland terms, or with a big turnover, they're increasingly applying significant. I think I've seen £150,000 and upwards in relation to some of the big prosecutions in recent years.
Okay. next question then, there's a comment there, thank you very much, very informative, and someone who would just like to know the difference between Crown Court and magistrates' prosecutions and inquests, and whether or not what's happening at an inquest essentially versus what's happening at the Crown Court or Magistrates' Court.
Yeah, well, that's a good question. I did mean to touch on that actually, because very often when there's an accident in the workplace, sometimes tragically a death, you end up with this triumvirate, this set of three legal routes coming at you. You have what we talked about today, the criminal process. You will generally have a civil set of proceedings as well, where the person injured or the next of kin, the family of the person who's deceased, will be seeking compensation for the incident. And thirdly, you will often have an inquest to deal with as well, where there's a death, obviously. Not all, it's very much at the coroner's discretion. The coroner will consider whether other legal proceedings have taken place, and whether those deal with in an open and transparent way with the facts of around the death. But sometimes you will have both a criminal prosecution and an inquest.
Okay, thank you. I'm just going to look now and see. I think that's all the questions. I'm just going to make sure we've covered them all off. If anyone has any final ones. Well, there is a final question that's come in there, actually more in relation to enforcement notices. So if a company is served with an improvement or a prohibition notice, should the company appeal is the question.
Should they appeal? Well, I suppose they should appeal if they feel that it has been unfairly served. I generally find that organizations, companies do want to work collaboratively with the health and safety executive if there is a prohibition notice or an improvement notice, that it's in everyone's interest to fix that, and the collaborative way of working is the best way. They can be appealed. It's an odd process for appealing. It actually goes to the industrial office of the industrial tribunals. So it can be done, but you have to be sure that there's merit in it, and there's a reason for doing it.
No, absolutely. I'm just going to have a look and see if we've had anything else in. No, I think that's everything, Ronan.
Okay.
So thank you very much for that informative talk, and also for the questions there at the end. So I appreciate your views on those. So thank you very much. That brings us to an end today. So I'll just finish off by thanking everyone for attending. As per usual, you know that we've been recording the webinar today, and if you think you have a colleague who might benefit from hearing some of the information today, then obviously, as you know, we circulate this to members, so Ernie will be in touch in relation to that. For any non-members that are here today, thank you again for coming. You're very welcome. So that brings us to the end, and I'll just say thank you everyone, do take care, and we'll catch up with you at the next webinar in October. Thanks. Bye-bye.
Bye.